Good morning, ladies and gentlemen of the jury. You have patiently listened to the evidence in this case, and you've made personal sacrifices in your own lives in fulfillment of this important civic function. I know all the parties connected to this matter thank you for the careful attention that you've brought to your role here in this matter. We acknowledge it has been difficult on you at times. We are now at the part of the proceedings that are called the closing arguments, and this is where the attorneys will summarize our respective cases for you. Following our remarks, Judge Murphy will provide you with her instructions and the rules of law. But please keep in mind that we all have separate functions here. You are the judges of the facts. Only you decide what the facts of this case are. Attorney Gavin and I were advocates for our respective positions. Judge Murphy is in control of the proceedings, and she will provide you with the law that is pertinent to this case. She will instruct you to apply the facts as you determine them to be, the laws as she gives it to you. Judge Murphy will define for you what is evidence in a case and what you may consider. And amongst the things that she will tell you is you can consider the exhibits that have been introduced to you by the parties and the testimony of the witnesses that took the stand during the case. But I ask you to recall, each one of you during your voir dire process, during the jury selection process, I asked each one of you, just because someone swears an oath to tell the truth, does that automatically mean to you that you will always get the truth? To that end, Judge Murphy is going to instruct you, caution you, and advise you that in deciding what facts to consider from the testimony of any witness, you may believe some of what that witness says, all of what they say, or nothing that they say, based upon the following criteria. How well was the witness able to recall the details and testify to them? What was the witness's manner while they were testifying to you? Did the witness have an interest in the outcome of the case or any bias, one side or another? How reasonable was the witness's testimony in light of all the other evidence in the case? And was that person's testimony contradicted by what that person said or did at another time, or by any other witness, or by any other evidence in the case? Judge Murphy will instruct you that if you think a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely on anything that witness said. So in other words, evidence is not just anything that is spoken from the witness stand. It must be credible. Judge Murphy will also tell you what is not evidence in a case such as this. First and foremost, she is going to tell you that these arguments, right now, the arguments of the lawyers, this is not evidence. As I mentioned earlier, the lawyers are advocates for our respective positions, and therefore we are inherently biased. Judge Murphy will instruct you that these arguments, or that the questions that are asked by the lawyers during the course of the case, that they're just argument. These arguments should point you to credible evidence in the case that supports the argument. Because argument that is not supported by credible evidence is just that. It is argument that is unsupported by the evidence. Because if it's not credible, then it's not evidence. Judge Murphy is going to tell you that you may not go outside the evidence, not to resort to guesswork or conjecture or speculation. She will tell you that while you may entertain an inference that a lawyer asks you to make, that inference must be drawn from credible evidence, and it must be reasonable and logical. It has to be reasonable and logical inference that relates to credible evidence. Because if not, then it's simply an inference unsupported by evidence. Now, in a few moments, the defendant's lawyer is going to come up here and he's going to tell you a number of things. He's going to tell you that the state has failed to prove its case to you because of two diametrically opposed reasons. He's going to tell you that the defendant didn't do this. Mr. Morales testified that home invaders killed Christine Holloway, left the only eyewitness to a brutal killing alive for some inexplicable reason, and then kidnapped Vanessa Morales. He is then going to suggest to you that if you do not believe the sworn testimony of his client, where his client raised his right hand in sworn oath to you, where he looked you right in the eye and flat out told you he was not responsible for this crime, then clearly he was on PCP, that this was a PCP-induced delusion, and that 5.5 years later, he still believes that there were home invaders that were responsible for this brutal crime. He is going to say to you, who calls 911 before killing somebody? He is going to point you to the 911 call and suggest to you that the tape supports the inference that his client was high on PCP. He is going to suggest to you that the brutality of the crime itself is evidence of aggressive behavior caused by acute PCP intoxication. He is going to suggest to you that there is no motive to otherwise cause such an attack. But remember, this is arguments of the defendant's lawyer. This is not evidence. Once Attorney Gavin lays out these inconsistent and diametrically opposed theories, I will come back and explain to you why the credible evidence in the case does not support the inferences that he is asking you to make, and why the only conclusion that you can possibly make from the credible evidence is that on December the 1st of 2019, sometime after 2 a.m. and before 6 a.m., Jose Morales intentionally caused the death of Christine Holloway by striking her in the head not less than 8 times with an instrument that caused blunt force trauma, thereby causing her death, and thereafter spending the next 36 plus hours systematically cleaning the crime scene in an attempt to erase all evidence and thereby existence of Christine Holloway until interrupted by the police beyond all reasonable doubt. I look forward to speaking with you again after Attorney Gavin's comments. Thank you, Your Honor.
Thank you, Attorney Gavin.
Thank you, Your Honor. Good morning, everyone. I guess I shouldn't have spent Easter Day at my